Hello friends, in my YouTube channel Advocate Amit Kumar Gupta, today I am going to discuss a very important case on section 263. The name of the case is JR Industries versus Principal Commissioner of Income Tax, and this case has been reported in 99 ITR at page number 422. The matter has been decided by Jaipur ITAT and the date of the judgment is 23rd November 2021. Friends, in this particular case, the facts are very interesting. 148 notice was issued to the assessee on the allegation that the assessee has made some bogus sales. When the assessment proceedings were going on, the assessing officer passed the assessment order by making an addition of 25% of the alleged bogus sales, meaning thereby there was no addition in respect of 75% of the alleged bogus sales. When the assessing officer made this addition, he does not made any inquiry about the bogus sales. The assessing officer on the ad hoc basis only made the addition of 25% of the alleged bogus sales. The assessee was before the CIT appeal. In the meanwhile, the Principal Commissioner of Income Tax initiated the proceedings under section 263 by alleging that the order passed by the assessing officer is erroneous and prejudicial to the interest to the revenue on the ground that the assessing officer had made addition only of the 25% of the alleged bogus sales without making any inquiry about the bogus sales. The point of the assessee was that the assessee is before the CIT appeal, so the proceedings under section 263 cannot be initiated. This was the matter sub judice in this matter. For this, the ITAT said that if the appeal has been filed and if the appeal has not been adjudicated, then the Principal Commissioner of Income Tax is well within its power under section 263 to do the revision under section 263. This was the first point. Further, the ITAT said that even if the CIT appeal has passed the orders on some grounds, and if the Principal Commissioner of Income Tax initiates the proceedings under section 263 on other grounds, and if that 263 is within limitation and it is into the jurisdiction of section 263, meaning thereby that if the order is erroneous and prejudicial to the interest to the revenue, then in that case, even if the CIT appeal has passed the orders, then the 263 can be done on the remaining matters. So this case is very important as far as dealing with the section 263 is concerned. In this particular case, the case of the assessee was reopened under section 148, alleging that near about 36 lakh bogus sale has been made, but during the assessment proceedings, the assessing officer on the ad hoc basis disallowed, made the addition of 25% of the 36 lakhs bogus sales, but he didn't make the inquiry. So the apprehension of the principal CIT was that the assessing officer has not made any inquiry and has not made the addition of the full amount. So before making any inquiry, the assessing officer cannot leave that 75% portion of the bogus sales when the main matter in section 148, because of the information from the investigation wing, is bogus sales. Then the whole bogus sales should be inquired into, and if the order has been passed without making an inquiry, so that order is erroneous and prejudicial to the interest to the revenue to that extent. So friends, this case is very important as far as section 263 is concerned. It emerges with 2 points of law. The first is that if the appeal is pending before CIT appeal, even then the Principal Commissioner of Income Tax can exercise his power under section 263, and even if the appeal order has been passed, then the Principal Commissioner of Income Tax can initiate the proceedings under section 263 if it is within the limitation period on the remaining grounds. If he is able to make the case that on that grounds and to that extent the order of the assessing officer is erroneous and prejudicial to the interest to the revenue. Friends, I hope that this case will be very important for your cases when you are dealing with section 263 cases. At the end of this video, once again I am repeating the name of the case. The name of the case is JR Industries versus Principal Commissioner of Income Tax. Thank you, friends.